I hope you are all well. I finally got your midterms. They varied. There were some that were really good, some that were good, some that were okay, and some that were not okay. I think with any class in any distribution, there's a curve. It happens pretty naturally. I think the midterms tend to be flatter curves because people don't study as much, but they fall naturally, however they fall. Here's how I am planning on doing the review process, and I want to explain my thinking so you know why this is. It's very hard to meet during the week. You have class, you have family obligations, you have work. I think trying to schedule any blocks of time during the week is simply not going to happen. So what I want to do is weekends. I may also do evenings, but I want to at least start with weekends. Now, how to do the weekends. Here's what I want to avoid. I want to avoid having 150 students on my queue Saturday morning. That is not in anyone's interest, sitting around waiting all day. So I want to find a way to sort people. Now, one option is appointments. The difficulty with appointments is people don't keep them. So if I give you a block of time and you're not there, I'm sitting there waiting. And then if you come in later, you delay someone else. And invariably, appointments aren't kept in a timely fashion because people don't always learn at the same pace. Some meetings might last 5 minutes, and some meetings may take 30 minutes, depending how much time I need with the student. So here's my idea. It's not ideal, but I think it's the most fair I can come up with, and I welcome suggestions. You all have last names, right, obviously, and your last name begins with a letter. If I just sort you alphabetically, then people with A's and B's will get their reviews first, and people with other letters get them second. So here's what I'm going to do. There'll be certain days where people with certain last names get to come. But it'll be sorted randomly. So let's just say Saturday will be last name F, N, T, P, and Q. I don't think there are any Q's, but assuming there are, right? So on a given day, that's your day, and you come on your letter. Lainey, I can't do appointments. It won't work with too many people. I've tried it, and it fails every time. It ended up wasting my time and everyone else's. So you'll come, and you'll leave Zoom on, and I'll call you when you're next in the queue. That way, in any given day, there might be 20 or 30 people in the queue, and there won't be 150 people in the queue. It's not ideal, but I think it'll be better than trying to make appointments, because appointments just never work because people don't keep them. I wish they did, but they didn't keep them, and I'm sitting there wasting my time. So this Saturday and this Sunday, I'll send you an email of whose letters are up. But you'll have certain time slots where if your last name begins with an F, that's your day. Now say, Josh, I missed my slot. Okay, that's fine. I mean, I know people will. Please don't email me and say you can't make your slot, because it's just it's not something I can help with. You just come to the next slot and you go to the bottom of the queue. It's not ideal, but I'll do the people whose letters first, and then eventually get to your letter. That will give you also a rough sense of where you are in the day. None of this is ideal. I really wish I didn't have to do this. I wish you were all in person, but we're stuck with Zoom world. I will have your exams emailed to you by Friday. I hope it's done sooner, but things just move much more slowly now with COVID. Things just aren't getting done quickly because people are just spread very thin. But here's how to make these sessions useful. Before you come to my session, reread the exam. No, don't just look at it. Reread the question. It might take you 20, 30 minutes. And then reread your answer. And then read the model answer or the memorandum that I circulated. Okay? Now, I'm saying this, you won't do it. You'll just show up. But here's my retaliation. If you show up and it's obvious you haven't done your work, I'll say, okay, go take an hour, read the documents, go to the bottom of the queue. I'm sorry, Quinn, you are the queue. I'm sorry. Oh, God. I apologize. There is a queue. Are there any X's? I don't think there are any X's. We have W's, we have Z's, but no X's. Okay. Well, I'll take that off the list then. what was I saying? Yeah. If you come to the session and it's obvious you're not prepared, I'll just say, okay, please go take an hour and go to the bottom of the queue. So don't waste my time and yours. By the way, Lainey, this is another reason why appointments don't work. Very often people come in, they're just not ready, and I have to just cancel their appointment and say come back later, which just screws up the entire scheduling. I find that probably half of the people who come to my office just showed up and didn't do any work, and then that's not good. It's not useful. I can't help you unless you help yourself. So please reread your answer. Reread the question, and reread the memorandum or the A+ answer. I can't remember which one I gave you, but read them both if you can. That will make it more useful. There will be some people who I read their exam and it's so bad, I'll say I'd like for you to retake it. Just retake the same exam again, and I'll grade it for you again. That is a very helpful option that students usually don't take me up on. They say, oh yeah, I'll do it, and they never do it. Okay, that's on you. But if I gave you that option and you don't take advantage of it, then that's really your that's really your problem, and it puts you in a tight spot for the final. All right. Macy, go ahead.
You may have already said this, and I apologize if you did. But are you going to send us our exams before?
I said that. Yes, I did say that. Yes. Okay. It'll be my secretary, which is why I'm not doing it right away. I'm going to have to call her again today to make sure she's going to do it on time. It just everything in the school just moves more slowly now. I can't quite I can't quite describe it. Just there's so many other things to do with Zoom University that the usual stuff just takes longer, and I don't have a good answer for you. But that's you'll get up into this week, I promise.
Gotcha. Thank you.
Yeah, you'll have definitely before Friday. I'm going to call her today just to verify. It's not like in the old days where I can just knock on someone's door and ask them. It's there's a process. I haven't seen. I haven't been in the building since March. It's a weird thing. All right. What else? I'm sorry. Yeah, there's a queue. I have to be a bit more sensitive to all letters of the alphabet. Okay. One other note, which I do want to discuss, is the exam. And I mentioned this last week, and a few of you came talk to me afterwards, and I want to just address it. We have an open book exam, which you'll be taking at home. I am not using the camera feature. I don't think it's effective for an open book exam because you are going to be looking at your notes, looking at your outline, flipping pages. It just doesn't work for an open book exam. I don't think it stops cheating. Some of your exams probably will have it on. That's the professor's decision. And I think the school is going to let each professor decide whether to have the exam monitoring software on. The second issue, though, that might be out of my discretion is one I want to just talk about for a moment, which is the timing. Smiha, go ahead.
I was just going to wait until after you asked the question about timing because I have two exams on the same day as your exam. I have my pro-res final and I have this final, and so I just wanted to know.
Are there others in the same? Are there others who are in the same position, Smiha?
Yes, I believe so.
Like a lot of other people?
I'm not sure. I know.
Now, I'm sorry. I don't mean to interrupt you, but usually they don't let you schedule a class where the exams are on the same day. Isn't that usually the practice? This is outside my pay grade.
I'm not sure. I mean, originally the pro-res final was in the morning, and I believe yours is in the afternoon. So I think that's why they let me register for it.
Oh, one was at noon. Was at 6? Was that the idea?
Mm-hmm.
Lainey, are you in the same boat?
Yeah, I didn't adjust my Section C schedule at all, but I added ProRes, so it doesn't conflict with your final, but I do have ProRes and another final in the same day.
But not at the same time?
No, not at the same time. Just two finals in one day.
Well, okay, thank you, Lainey. Well, let me bring you up to speed. You may recall during the spring semester, you were given a window, right, where you could take your exam at any point during the day. It was a 12-hour window. I can't remember. There might be something similar this semester. So in other words, if you have an exam, you would be able to take it from like 9 a.m. till 9 p.m. pretty much. The reason why the school is considering this change is to accommodate students who aren't able to get quiet time at 6 p.m. or noon, as it were. Childcare is tricky. Kids don't work on your schedule. They work on their own schedules. And from 6 to 9, they may not be able to have childcare or daycare or babysitters because of the COVID situation. So the thinking is that we allow people flexibility. So you have 2 exams on one day. In theory, you take your ProRes exam at 9 a.m. and then my exam at 6 p.m. Right? Space it out so you don't kill yourself. So you say, "Wow, Josh, that's great. You know, why are you telling us this? Isn't that an awesome thing?" I want you all to recognize what happens when you have a window. Let's say you have a study group with 4 people. And one member of the group takes the exam at 9 a.m. And then at 12:01, they'll have a group chat. They discuss what happened on the exam. And they write down the questions and they discuss it. And then for the next exam, person number 2 of the study group takes the exam at 9 a.m. and they all split it up. Don't think this won't happen. It probably will, if there are windows allowed. People cheat. Yeah. Macy says we compete for grades. Yeah, people cheat. Look, the curve isn't that important. I know you think the curve is an incentive. It's not. People cheat. People cheat. There's a baseball team in town that cheated, right? People cheat. Sorry. People cheat. Whoa. Sorry, too soon. People cheat. And it's unavoidable. So we haven't decided as a faculty what we're going to do. I think we're discussing on Friday. I just want you to be apprised of that. But it's a hard issue. In my mind, I don't think it matters so much for my exam because it's an issue spotter. If people cheat, I'll know very quickly. It's actually remarkable how dissimilar papers are. In a section of 70 people, consistently people don't write the same things. It's just I see variations. I read them all closely. So if anyone tries to cheat, I think I'd smoke it up pretty quick. I remember one year, a couple students were in a study group and they had a genius idea to pre-write answers. They basically, for example, I always ask stuff about the founding era. So I said, I have an idea. Let's just write stock answers about the Federalist Papers. We could just, type them into our exam. But they didn't even know what the question was. So a few people had like the exact, or not the exact, but like almost the same verbatim sentence on the Federalist Papers. Like, wow, that's suspicious. And, it turned out this was a study group. And they had pre-written answers. Like, okay, I guess you can do that. That's, I guess that makes sense. So, nothing came of it, but I flagged it and I figured it out. It happens, but if you try to cheat on my exam, I'll know very quickly, and it's not worth it. So Macy says the incentives for the grades, yeah, the bigger incentive is getting caught. Your career is in a bad spot. It's in a terrible spot because you get a letter to the bar saying that you cheated on an exam, and you may not be able to be admitted. It's not worth it. Other classes, I'll be candid, are easier to cheat on. If it's multiple choice, short answer, they're different. It's a little bit easier. With multiple choice, the software randomizes, so A, B, C, they all get flipped around. So you can't just memorize A, B, C, D, like we did in high school. You can't do that. But it's still possible. Yeah, I mean, Macy says you won't have a career. You might get expelled, yeah. You may never make it to the 3rd year. So I give that to you, and I know I'm telling you don't cheat, and there's at least 3 or 4 of you, if numbers served, they're probably saying, screw it, you won't know, right? Whatever. People cheat. It's part of human nature. They think they can get ahead, think it's worth it. People don't behave rationally. They don't. People don't. They very often act against their own self-interest. They think it's worth it. You're taking, I guess, professional responsibility now. How many cases do you study in ProRes of lawyers who took the shortcut? My God. Is that the entire freaking class, right? Of lawyers took shortcuts to try and get one past the court or get one past their client? How often does that happen? Every case in your semester is about lawyers who took shortcuts and tried to cheat. They cheated their client, they lied to the court, they didn't disclose whatever, right? There. Just do the right thing and you'll be fine. I'm spending time on this now so I don't have to deal with it at the end of the semester. That's why I'm spending time on it now. I don't want to, but I'm trying to make this point upon you very clearly. All right. Happy to work with you. Just don't cheat. If you cheat, you're in trouble. All right. Any other questions? No? Good. Always happy to help, but don't take a shortcut. Oh my goodness, it's just not worth it. Not worth it at all. I remember I had a friend in law school. I think it was first semester. It was either contracts or torts, and he had forgotten his restatement at home when he began the exam. So he went to the hallway and he called his wife to bring his restatement to the school. They lived close by. And then someone saw he was on his phone, and he had this entire proceeding, where he had to show his phone bill and show that the call placed in that time was to his wife. It lasted 20 seconds in duration, and his wife had to go give a statement saying that he just called her to get his restatement book. And it was something so innocuous, but it almost uprooted his entire first year of law school. It was his first or second semester, I can't remember. Eventually, he was cleared, but it's a huge deal. Every year there are people who are kicked out for cheating. It happens across the country and they get caught. So just don't do it. Okay. All right. Let's do some common law if we can. Enough scaring the crap out of you all. Sorry, I didn't get the fear of God talk, but I think it's important for this semester in particular because the incentives will be there greater than ever before. Oh, someone asked me about taking the exam in the building. One of the advantages of having the staggered time slots is not everyone's rushing for the study halls at 6 p.m. exactly, right? There's more space in the building if you can stagger throughout the day. So that's another advantage. Someone asked me about printing out the exams. There's no good way to do it. Because for me to print out the exams would let you have it early. And once you have it early, that makes cheating really easy. So I'm not giving you that. Not going to give you that, sorry. All right. Let's take a look at the class notes. And let's try to recap our class from last Monday. Let's do question number 1, short answer. And let's see if we can get your rule statements going. What are badges of slavery? What does that phrase mean? Badges of slavery. Okay. All right. All right. Who's next?
It's me.
Who's me? Oh, Raymond. Okay.
Raymond, yes.
Okay.
So, are you ready for the answer?
Sure.
Okay. I don't remember if we came to an exact definition of this, but kind of what I understood it was just practices that mimicked the institution of slavery that kind of solidified Black Americans' inferiority in America. So I don't know how accurate that is to say.
Okay. So practices that, You said mimic? Is that the word you used?
Mimic, yeah.
Okay, practices that mimic. Give me an example of what might be a badge of slavery.
I think you can make an argument. I mean, I think they kind of reject this in the case we read today, but I would consider segregation to be that. Maybe not being able to vote would be an example of that. Not being able to own property, not being treated as a citizen, for lack of a better term.
Okay.
Not being able to contract.
All right, so Raymond, let me ask you a follow-up. Are the badges of slavery anything that reflects the differences among the races?
Yes.
All right. So anything that reflects that black and white people are different, would that be a badge of slavery?
I'm going to change my answer to no to the initial question you just asked there, because there are differences amongst people, but it wouldn't be everything. It would be the differences that reflect the difference between a free person and someone in bondage. I guess whatever that difference would be, I suppose.
All right. Is that Laura? Laura, are you here?
Yes, I'm here.
How did you define badge of slavery, Laura?
I just said reminders of inferiority, slavery.
Reminders. Okay, so what does that mean, reminder?
Like anything that would be kind of a placeholder or under the guise of, segregation or anything that would
Okay, you keep saying anything, anything. So I'm trying to get it. Is it everything? Everything that reminds you of slavery is a badge of slavery? Is it everything?
No. It said that in the case that discrimination itself wasn't a badge of slavery.
Well, no, that's the case. We'll get to the case in a minute. I'm just trying to figure out. Laura, let me ask you maybe a more fundamental question, more basic question. What is slavery?
The imprisonment of someone else against their will for your profit.
Is it only physical bondage, only physical imprisonment, to use your word? Is it just physical confinement? No. Is that it?
No, because not every enslaved person was, kept in shackles. Being physically imprisoned isn't the determination. It's more of the.
Right, but did slavery go beyond what you might call chattel? Right, chattel slavery, where there was a forced labor. Was slavery only about forced labor?
No. The lack of autonomy that people had, and lack of choice, and lack of rights and freedom that other people are experiencing.
All right, Alejandra here.
Yeah. Hi.
Hi. Yeah, I hear you just fine. Thank you. How do you define slavery? We'll get to badge in a minute. But how do you define the phrase slavery?
Slavery is basically taking advantage of other people who are inferior than you, or who you perceive as being inferior to you, and then basically making them do everything for you, like all your work.
Okay, so I want to just focus on one of the words you said. You said the word inferior.
Mm-hmm.
How does the word inferior play into this concept of slavery?
I'm sorry, you said how does it play into what?
How does the word inferior, right? What does inferiority have to do with slavery? I think you're getting towards where I want to go.
Well, I guess they would pick black people because they felt that they were inferior to them, as opposed to taking other white people. Like,
Okay.
I guess they were indentured servants, but they weren't like the same.
Well, just hold on a second. So let me just wind you back to just a minute. So with your understanding of slavery, there was both inferior and I guess superior. You might want to say, right? They're two sides of the right. So it was understood that some races were superior and others were inferior. Is that kind of what you're getting at?
Well, that was the view.
Right. Of course, that's not your view. Of course, that was the view held back then. So, what then might be a badge of slavery, if we understand slavery in terms of the sort of racial inferiority superiority complex?
In that case, a badge of slavery would be like a reminder of their inferiority.
There it is. Thank you, Alejandra. Yeah, I think that's what I was getting at. Took a few people. I think I got there. Okay. So, I think what's important to discuss here is that the phrase slavery was not limited to what you might call the forced labor, or what is used in the Constitution, involuntary servitude. Slavery became what was known as an institution. And people use this word, what the hell is an institution, right? It's not like a building where people who are sick go, right? An institution meant an entire belief system, an ideology, right? A way of life, right? An entire way of living. And at the core of slavery was not just, okay, this is a person who's going to be working for us. It's that this is not even a person. This is what Dred Scott said, just property, right? That basically this is the natural order of things. This is how the world was created, with different races who are inferior and inferior. If we start from that premise that slavery was not just about forced labor, involuntary servitude, but that slavery was bigger, that slavery involved this sort of racial inferiority, then the concept of the badges of slavery takes on a different significance, right? Because it's not just things that remind you or perpetuate or mimic or resemble forced labor. The badge of slavery were things that remind you of inferiority. And what are the things that might remind you of inferiority? I think, I can't remember who said it a minute ago, but discrimination might be one of them, right? Forcibly having a business where you say, okay, if you're white, you're allowed to enter this business, but if you're black, you can't enter this business. A theater or a hotel or a railroad or whatever it happens to be, right? That is fastening a badge of inferiority, a badge of slavery, and saying, look, you might be free to not be a forced labor, but I'm still going to remind you that there is this inferiority of the races, right? This is what Justice Harlan was getting at in his dissent in the civil rights cases. That the 13th Amendment was not only designed to eradicate physical slavery, physical bondage, rather, the 13th Amendment was designed to give Congress power. Give Congress the power to eradicate these reminders, these badges of slavery that perpetuated this inequality of the races. But the court rejected that argument in the civil rights cases. They rejected it very forcefully, 8-1 vote. And what the court said in civil rights cases is that the concept of badges of slavery wasn't about inferiority. It was about physical bondage. So unless you actually have people who were being enslaved, then Congress could do nothing. And there was one line in the civil rights cases that sort of sticks out in my head, at least, where they say, if everything is a badge of slavery, then it runs, the 13th Amendment into the ground, right? If everything about inferiority is a badge of slavery, then it's too broad. You can't have this definition of a badge of slavery that's so expansive that virtually anything is. And the court says, look, discrimination, it's what people do. It's not slavery, and therefore Congress can eliminate it. They hint at this issue in the civil rights cases, but they discuss it very, very frankly in Plessy, which we'll get to a little bit later today. But I want everyone just to get the 13th Amendment, at least as interpreted by the civil rights cases, gives Congress very few powers, and Congress can only act when there's some sort of badge, right? Some sort of actual bondage that's going on, not just promoting the perpetuation of inequality of races. Okay. So questions on badges of slavery. No? Okay. Let's try question number 2. Right. Question number 1 was focusing on the 13th Amendment. Let's do question number 2, for example. Question number 2 is, what is the state action doctrine? What is the state action doctrine? I think Virginia is next. I'll give you a minute. All right. In about 10 seconds, Virginia, just raise your hand. Thanks. Okay, Virginia, what is the state action doctrine? No, Virginia?
It was talking.
Yeah, you are. Okay, sorry. Go ahead.
It was talking about how Congress couldn't remedy civil rights violations based by private parties.
Very good. Right. What are the only types of actions that Congress can regulate?
Federal.
Sorry?
Federal.
Well, who does the 14th Amendment regulate?
The states.
Okay, so I'll ask the question again. What are the only kind of actions that Congress can regulate under the 14th Amendment?
State action.
There it is. Okay, very good. Thank you so much, Virginia. The 14th Amendment provides that states cannot deprive people of their life, liberty, or property without due process of the law. And the states cannot deprive people of the protection of the laws. The civil rights cases was a case involving a federal statute. Congress enacted the Civil Rights Act of, was it 1875? I always blank on the year. There were several of them. 1875. And this law made it a crime to segregate on the basis of race. Here, Congress thought it was relying on its powers under the 13th and 14th Amendment. Well, the court already rejected the 13th Amendment argument. Then we talked to the 14th Amendment argument. The 14th Amendment, the court says, limits only state action. Right? State action. Private discrimination is not state action. Have you done in property yet the case Shelley versus Kramer? About racially restrictive covenants? Have you done covenants yet in property?
We covered that last semester. I remember that somewhere.
You did covenants in property 1?
No,
No,
but I remember
covenant.
talking about the covenants. Do we not? Or am I crazy?
We've done covenants recently.
Okay, well,
But covenants is on our actually going into in a couple of weeks.
okay, well, anyway, you'll study a case I'm almost certain called Shelley versus Kramer. Here, I typed the name in your notes. Check if that's on your syllabus. I'm almost certain you're going to cover it. Shelley versus Kramer involves a restriction on land that says only people who are white can live there, and whether that's an enforceable property agreement. And one of the issues in that case is, can private people make a discriminatory agreement? And the short answer is yes. The rub is they couldn't enforce that agreement in court, because when you enforce the agreement in court, the courts are involved. That is state action. But the civil rights cases is still good law. To this day, private citizens cannot violate the 14th Amendment, right? If a person is racist, if a person is, biased towards people on the basis of their race, whatever it happens to be, they're not violating the 14th Amendment. But, and here's the big but, there are statutes. A few of you put this in your minute poll asking about this. There are federal and state statutes that prohibit discrimination in housing, in employment, and in many other spheres. So if a person, say, fires someone for, their race, they're not violating the 14th Amendment. Instead, they're violating the Civil Rights Act of 1964. We cited that law in Katz, Vacuum McClung, and Heart of Atlanta Motel. Right? So the modern basis for anti-discrimination laws is not the 14th Amendment. The modern basis for anti-discrimination laws is, as we know, the commerce and necessary and proper clauses. Right? So civil rights cases is still good law. Congress cannot remedy private discrimination on the basis of race with the 14th Amendment. They have to turn to the sort of strange argument that people are actually commerce and that the goods used in the kitchen traveled into interstate commerce, all this other stuff, right? Now, you'll remember in Katzenbach, there was a concurrence by Justice Douglas. Remember that? And Justice Douglas said that really the way to restrict discrimination is Section 5. Right? Use the 14th Amendment. Why are we using the stupid Commerce Clause when we have racial segregation going on in these businesses? But the Katzenbach case and Heart of Atlanta affirmed the civil rights case. They didn't disturb it. So civil rights case is still good law. Still good law. Now, someone asked this question in the minute poll, and I want to address it. If Justice Harlan was correct, and Section 5 allows Congress to regulate state action, and if the 13th Amendment was really limited to limiting racial inferiority, how far would that ruling stretch? In other words, could Congress use its Section 5 powers and its 13th Amendment powers to prohibit gender discrimination? Slavery was about racial inferiority, we said. I suppose there was some gender inferiority, but that wasn't really how it was understood. Could Congress use the 13th Amendment to prohibit discrimination against gays and lesbians? Was that even was that a debate going on in the 1800s? That was even, was that part of the slavery debate? So when you read the word slavery in this sort of racial inferiority complex, I think it provides a very good grounding to discrimination between black people and white people. But it doesn't get you to other types of discrimination. So we learned from Justice Harlan that at the time, Chinese people had discrimination. I think of Korematsu with Japanese people some years later. Can you fit discrimination against Asian Americans into the umbrella of slavery, the badges of slavery? So this badges of slavery argument has appeal. And I think it's historically strong for racial discrimination between black people and white people. But it's harder to extend that concept of badges of slavery to other types of discrimination. That's why I think the court went down the Commerce Clause route, because the Commerce Clause route doesn't care why there's segregation. The history is irrelevant. All that matters is that people are driving on highways, and that barbecue joints in Birmingham are buying beef from some out-of-state place. Okay. Questions?
Might have to think. I'm sorry, Professor. This is Lainey.
Okay, go ahead.
Good morning.
Morning.
I have to think this through more. But did we just make a stretch where we're saying the Commerce Clause is actually a protection?
What do you mean protection?
I don't know. I have to think it through more. Thank you.
Are you asking if the Commerce Clause is used to protect, against discrimination? Is that what you're saying?
Yes, because we didn't want to rely on a protection that protects only one race. We want to be able to protect all the different classes that might be discriminated against.
Yeah, I think I answered your question. So I think Lainey's asking is, if Congress wants to protect as many people as possible, then perhaps the Commerce Clause is a better route than the 14th Amendment. Because the 14th Amendment would give a very strong protection for certain types of racial discrimination, but I think it's perhaps a weaker argument for other types of discrimination. Is that your question, Lainey? Okay, she's nodding.
Yes, sort of. Now I'm reading my pocket Constitution. I don't know.
That's okay. You're allowed to. You're always allowed to read the Constitution. I think that's a fair question. Let me, if I can just take a step back. Law students often approach a question this way. They say, well, this is the just result. So I like the reading of the Constitution that allows this just result to happen. And that's a very understandable instinct, right? It's like, well, I know what the right result is, so we're going to pick the answer that gets you to that result. Sometimes the answer might be, there's a very good result, which we all agree upon, but the laws as they exist now don't let you get there. So is the answer you simply read the provisions in a creative fashion to get there? Or is the answer to change the law, or to perhaps let the states take care of it? So I just want to, just with the slightest, not for Lainey in general, but just the slightest caution to think that, well, because there's some just result, the Constitution must let you get there. I think what this class should teach is that the document as drafted may not always be perfect, and it may not always let you get to what you think the just result is. And people in good faith often disagree on what the just result is. And I think the Harlan dissents start to peel on that tension, right? Because it's, wow, this is this great badge of slavery. This is awesome. Oh yeah, what about Chinese people, right? And it sort of hits you with like an anvil on the head, like in a cartoon. It's like, whoa, where'd that come from? But every doctrine you pick has strengths and weaknesses. And by going down one road over the other, you're cutting off certain paths. And it's very hard. It's like running a minefield, right? Of how to get from point A to point B without stepping on a landmine. And that's why these Supreme Court decisions are so carefully studied, because the justices are trying to avoid stepping on mines, and they usually don't, because it's hard not to. Lainey, go ahead.
Okay, so if I go to Section 8, the enumerated powers, we have general welfare. And so no discrimination against any classes would serve the general
Whoa. What general welfare? Read the rest of the text around general welfare.
And provide for the common defense and general welfare of the United States. So not the people of the United States.
Well, you're reading the preamble, right?
Yeah, and trying to see how the Commerce Clause reaches to that, to protect people from to protect all people, all classes from discrimination. Because if we don't want to rely on just a clause that protects only one race.
So if you're saying the general welfare clause means Congress do whatever it wants in the general welfare, then this is a very easy class. Then the answer is Congress do whatever it wants. Right? In other words, if you read general welfare that broadly to be, whatever is good, then Congress can do whatever it wants. And then there's no limits on federal power.
Okay, I'm still thinking. Thank you.
That's okay. Right. I mean, this is one of the uncomfortable aspects of this class where you recognize that maybe there's something really good Congress should do, but the Constitution doesn't empower Congress to do it. Or if Congress has the power to do this for the common good, then maybe a government you dislike can use that power for evil, right? Because once you give it power, it's seldom surrendered. Raymond writes, would there be a police power, right, where the federal power be basically the same as the state power? I'm not trying to answer questions here, just I want you to recognize that when you give a power to do X, that's very broad, whatever X is, you're probably also giving power to do Y, which you may not like. Right? Power is not cabin. Once you have it for good, it can be used for evil. It's just, as we come up to an election, it's a good thing to think about. Whenever you think about executive power, don't just think, what if my guy has, what if the other person has it also? Would you be okay with the person you disagree with exercising that power? Or even the courts, right? What if it's a majority one way or a majority the other way? Would you be content with someone you disagree with exercising that power? And if the answer is no, then maybe that's not a power that should have. Generally, the party that's out of power is usually screaming about, we need to limit power. And the party that's in power is like, we need to expand power. And just that's just the nature of our republic. It happens every 4 to 8 years. Everyone just sort of flips on the other side. All right. Anything else on this? I always try and give this a little reality check for Conlo because it doesn't really hit the first half of the semester, but it hits hard in the second half. Who's next? Oh, Cassidy, I think you're next.
I am here. Good morning.
Good morning. Thank you. Cassidy, you wanna give me the facts, please, in our next case, Yick Wo v. Hopkins?
Yes. San Francisco bans wooden laundries. Most of the laundries in San Francisco at that time were wooden. And so the people having these wooden laundries needed permits to
Why?
operate.
Okay, so let me just take a step back. Why would the city ban wooden laundries?
Because wood burns easily.
Okay, so there's a fire risk, right?
Yes.
Okay, so were they banned altogether? Could no one have wooden laundry?
You can operate a wooden laundry with a permit.
Ah, a permit. Okay, so what do you need to do to apply for a permit? What did you have to demonstrate?
I don't think you have to demonstrate anything.
What do you mean? What do you have to show? You have safety protocols. You have to.
Yes, I'm sorry. That you had to show that you met certain safety requirements and regulations that they had for the building.
No. I think you're right the first time. There were safety inspections, right?
Yes.
But for this specific permit, were there any criteria that you had to meet?
No, there was no criteria. They just had safety inspections. If you passed them, then you passed them.
All right. So, let me thank you, Cassidy. So, in Yick Wo, right? This is the case we have right here. You had a situation where the city has an interest in safety. Okay? The city has an interest in making sure that you don't have these wooden structures burning. Everyone agrees that, or not everyone, but most people agree that the city and the government can prohibit dangerous uses, right? So in this case, you had a person who was of Chinese descent who operated a wooden laundry. And he operated his business for nearly 20 years. And year after year after year, he was inspected. And they checked to see whether his appliances, which basically mean, what's a laundry? You have a pot of water that you boil in, right? You have your wood, all the things you have, right? All this stuff was considered safe. Okay? But then, after another inspection, he was denied the license. Now, for sure, there have to be inspections, but this is an important part. The denial of a license did not have to be justified. In other words, even if you pass the inspection, which Yick Wo did, you could still be denied your license. Right? Why? The ordinance gave the government absolute discretion over whether someone got their license. A license could be denied for a good reason, a bad reason, a made-up reason. It's just make crap up, right? Or no reason at all. It was completely discretionary. Who's next? Michael, you here?
I'm here. Good morning.
Good morning. Thank you. Michael, what's problematic about having absolute discretion? Absolute discretion with no guidelines, no guidance, no rationale at all. They can grant or deny a permit for whatever reason, no reason at all. What's problematic about that approach?
I don't see any way that you could be really held liable for infringing on someone's rights. There's nothing in the law that says you have to act a certain way.
Well, Michael, let me just hypothesize for a minute, right? If I tell you that you're a professor and you can give grades to students based on whatever criteria you want, doesn't matter what they write in their exam, you can assign grades in any fashion you want. School's not going to care. Do whatever you want. Exam or no exam, we don't care. What might there be a risk of you doing if you had that sort of absolute discretion?
I would not be calculating their grades based on what they know or however they played by the rules, but rather how I thought about the person.
What do you mean by the person? I think I know what you mean. Just elaborate.
Like, I guess my own biases would determine.
Yeah. So what if you really like a student?
Yeah, get a good grade.
What if he just really pisses you off, you don't like them at all?
They would not.
Yeah. All right, thank you. I'll give you enough. Yeah, but we have blind grading. Don't worry. I don't know who any of you are. It's actually for the benefit. But I think Michael is hitting on an important point. One of the reasons why society establishes rules and guidelines is to minimize the risk of bias. If I know that I have an exam and there's a question, the answer is A, B, C, D, or E, and I say the answer is C, right? The answer is going to be C for everyone, whether I like you or not. Essay exams are a little bit harder, but I try to have a rubric, right? But if there's a question and the answer is whatever I want it to be, right? I can use my own biases to dictate what grade I give you. If I really like you, oh, that's an A answer. He's a great student. And if I don't like you, oh, he's a terrible student. That's an F. All right? Now, this is a fairly easy example with, giving grades. But let's talk about a business, right? In this city in San Francisco, there were, what was the number? the overwhelming majority of people who have wooden laundries, of the 2/3, were owned by people who are of Chinese descent. All right? The city enacts a law that is justified in the public interest, right? It says, if you want to have a wooden laundry, you have to get a permit. Who's going to argue against that? That makes sense, right? If you have a wooden laundry, it's dangerous. But then the city establishes 0 criteria to decide who gets it. So if you have a laundry and you apply for the permit, you have no idea what you have to do to get the permit. Right? There's no criteria. You have no notice of what you have to do. But then there's also the risk. Right? Heather. Excuse me. Heather, what is the risk in Yick Wo when you have these government inspectors with absolute discretion? Or what actually happened here is a better way of putting it.
The risk in what happened was that people they used it as like a form of discriminating against the Chinese operators versus non-Chinese operators.
Well, how? How did they use this discretion to discriminate? Just spell it out for me, please.
Well, since they didn't have to have a reason, then they just didn't give them the permit, so then they couldn't operate.
Well, they had a reason, but did they disclose that reason to the public?
No.
What was the reason?
Because they were Chinese.
Yes. They were being racist against the Chinese laundromat owners, okay? Right, so this is a common theme in Supreme Court cases, right? Where the court will say, okay, you made this racial classification, right? Why did you do it? And the government says, well, this wasn't a racial classification. We were trying to ensure that we didn't have these dangerous wooden laundries. Okay. Then what were your criteria for making sure the laundries were safe? We have none. Oh, you have no criteria. So how are we to believe you? Right? This is the sort of dialogue that goes on in court. The plaintiff comes in and says, hey, the government's being racist, right? They're denying permits to all the Chinese people. And the government says, no, we have this program to keep the laundromats safe. And then the court poses a pivotal question. How does your law keep the community safe, right? What criteria are you following that ensures safety, right? And if you're the government lawyer here, you're kind of in a tough spot because you have no criteria. It's a completely random program. Then the court says, well, if your program is completely random, how on earth is it trying to keep people safe? Right? If your program is completely arbitrary, it's not designed for public safety. And here's the key move. If you're not doing this for public safety, why are you doing it? Right? What's the real reason why you're doing it? You can't give us a good reason, so we're going to presume there's a bad reason. See how that works, right? If the if the court asks you, why are you doing this racial classification? And you can't give a good reason why you're doing it, the presumption becomes there's a bad reason why you're doing it. And in this case, the bad reason is that they have hostility towards the Chinese people. What I just gave you in so many words is how scrutiny works. We've used this phrase before, scrutiny. But when you use a racial classification, the court is very skeptical because usually they're not good. Usually racial classifications are bad. But this case is different though. They didn't pass a law saying all Chinese people have to lose their licenses. They passed a law that looks neutral. It says, well, if you want to run a permit, so if you want a laundromat, put in for a permit, apply for a permit. And it just so happens that almost all the people who are Chinese get denied their applications, and all the white people get their applications approved. So Yick Wo was a very significant case. It was one of the first decisions, if not the first, where the court said, even if a law is neutral on its face, if it has an improper motivation, it's unconstitutional. Right? Even if the law is neutral on its face, if it's enforced in a improper fashion, then the law is unconstitutional. And there's this very famous phrase, and I want to read it for you because it's very famous. It's quoted all the time, so I'm sure you'll see it in your practice. Let me read it to you. It says, "Though the law itself be fair in its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances, material to their rights, the denial of equal justice is still within the prohibition of the Constitution." So this was a very significant passage, right? A very significant passage. All right. Who's next? Is that Durrell? You next?
Yes, sir, I'm here.
Durrell, yeah, thank you, sir. Help me out here. What does that mean? An evil eye and an unequal hand. What is that getting at?
Yeah, so I think it's going to be kind of similar to what we were talking about in this case, is that they were distributing it more like in a discriminatory fashion, and like they're giving preference to people that are white instead of people who are Chinese.
Well, just evil eye. I mean, what does that mean with an evil eye?
I guess looking at people differently. So like they're looking at one person with a positive outlook and another person with a negative outlook just based off of something that's arbitrary and that's not really like a real reason to look at somebody with that kind of eye, I guess.
What's unequal hand? What's that getting at, Daryl?
I kind of think of that as like laying down like kind of like a judge laying down the gavel in like an unequal manner. So like in some situations being like equal, being fair, and in other situations being not fair, and it's not really for any reason other than their own discretion of what they can be fair and unfair about.
Okay. All right. That's good. Thank you, Daryl. All right. So we have this discussion of this evil eye and unequal hand, and I just want to put this decision into focus, right? People read this like, oh wow, that's great, Josh. I love that ruling. Okay, Plessy came a couple years later, right? You have Yick Wo, which was like 1886, and then Plessy came 10 years later in 1896. And so people ask, Josh, 10 years apart, that's not a very long time. How do you reconcile this evil eye, unequal hand business with Plessy, which was a separate but equal doctrine, right? How do you reconcile those cases? We'll get to Plessy in a few minutes, but I want to just put Yick Wo into focus. Yick Wo was a very specific type of case where the government was requiring licenses for people and requiring people to obtain licenses. Okay? They're requiring them to obtain licenses. This was a license that was necessary for their business. And the court says, and I'm not making this up, this is like slavery, right? To force someone in their livelihood to not be able to get their permit, they can't work, it's like slavery. And then you go to Plessy about a decade later. It's like, yeah, whatever. Yeah, separation's fine. Right? How do you square these cases? And people, if you want to raise your hand, that's fine. People say different things different years. Some people say, well, the court was more amenable to Chinese people than to black people. Perhaps, maybe that's part of it. Maybe that 1896 versus 1886, the times changed, that there was still hope of Reconstruction, and then things by the 1890s changed. That's also possible. There's another answer that's not very satisfying, but this case concerned property rights. It was a business license. And there was a strong movement in the late 19th century and early 20th century to protect property rights. The right to work, the right to contract. Think of slaughterhouse, right? The right to, the butchers to work. Or Myra Bradwell, right? The right of the woman to get her law license. I think that was part of it, that there was a strong sense of having a right to property rights. There's another aspect that's not in your book, but I want to just flag. Yick Wo was a poor laundry worker. How on earth did he appeal his case to the Supreme Court? How did he afford this over a fairly small fine? The Chinese government was bankrolling this case because the Chinese government was not happy that their people were being put out of business. So this was a case that also about international relations. And there's some references to, the Kingdom of China, the Emperor of China, this stuff. There were some treaties involved between the United States and China that guarantee the rights of Chinese people to work in the United States. And lurking in the background were these treaties where the court was saying, whoa, we can't have the state of California screwing up our foreign relations. We have to honor our treaty obligations. So I don't want to say this case didn't have a huge impact, but this evil eye and unequal hand language would not become important until the 20th century, right? So for a period of several decades, this language sort of just didn't really matter. But much later, when the court began to look at civil rights more carefully, Yick Wo became a very important precedent. It was sort of an outlier for its time, kind of like Strouder, but it was very significant in the long run. Excuse me. Okay. Questions, my friends, on Yick Wo? Yes, go ahead, Smiha.
Could you just re-explain the evil eye and unequal hand part? I'm a little confused about that still.
Sure. The unequal eye, unequal hand, right? The evil eye refers to an improper intent, right? An improper intent. Here, the court suggests that their improper intent is hostility towards Chinese people, right? Because the reason they gave doesn't make any sense, that there's any sort of rationale, it's completely arbitrary, the court assumes there's some sort of evil intent. The unequal hand refers to how the law is administered, right? Where people are getting their licenses granted or denied kind of randomly. There's no criteria, there's no basis, it's just being unevenly applied. So the evil eye refers to just the bad intent, like you have just this wicked motivation. And the unequal hand refers to this unfair administration.
Thank you.
Okay. All right. Other questions? Laura?
So is the equal protection part of this case, like the most important part of the case, is like the due process part of the case not really as important as what they were saying about the equal protection?
Well, yeah, though it's a good question, Laura. Let me address that. Most people, and when I say most people, I think most professors see Yick Wo as an equal protection case. I used to think that, and I changed my mind over the years after teaching it year after year. And just bear with me for 1 second. I need to jump ahead. In about a week or so, we'll study the Due Process Clause. And we'll begin to study cases that involve what's called economic liberty, right? Where the state restricts how many hours you can work, the state restricts working conditions, the state restricts wages, etc. Those are all due process cases. The argument is that you have the liberty of contract, and the state can't arbitrarily deprive you of that liberty of contract. Yick Wo makes a lot more sense as a due process case than as an equal protection case. The concern isn't so much that they're treating Chinese people differently. The concern is that they're doing so without a rationale that's an arbitrary law. And discussions whether law is arbitrary are always about due process. They're not about equal protection. So most people see Yick Wo as an equal protection case, and it is, but I think due process plays a very important role in there as well. So Laura, to answer your question in a very unsatisfying fashion, the answer is both. Which is not the answer students want to get. Okay. Questions on Yick Wo? All right, let's go on to Plessy. Who's next? Gerald was last. Lauren, you here?
I am. Good morning.
Good morning. Thank you. All right, you want to give me, please, the facts in Plessy?
Sure. So in 1890, the state of Louisiana passed state legislature that required on passenger trains the separation of black and white passengers into separate cars.
Okay. Let me just stop you there. What year was the statute passed?
1890.
1890. What year was the 14th Amendment ratified? Do you remember?
Oh gosh. Before that.
Yeah, how far before? Do you remember just roughly what year?
I don't.
Okay, 1868. I'll help you out here, right? Okay, so the 13th Amendment was 1865, and the 14th Amendment was 1868. So we have, if my math is right, almost 30 years, or 20, I can't count, math is not right, 22 years from the 14th Amendment to Louisiana enacting this segregation ordinance. Why is that significant, Lauren, that you have 20-something years passing before we actually get these sort of segregation ordinances? Why is that significant?
In terms of significance, I'm not sure. I think it's kind of crazy. But they were, the way I looked at this is they found their statute to be valid.
No. We'll get to that in a second. My point is a little bit different. Did the southern states enact these sorts of segregationist measures immediately after the Civil War ended?
I'm guessing no.
No. Why do you think so much time elapsed before these sort of measures built up?
Maybe they thought they weren't being watched.
You're actually very good. What was going on in the southern states right after the Civil War finished? What was that period called? What do we call that period? It begins with an R. Yeah, good. Thank you, Lauren. So immediately after the Civil War finished, the southern states were in a period known as Reconstruction. And Reconstruction is exactly what it sounds like. The northern states tried to reconstruct or rebuild the southern states. The southern states couldn't run their own governments, right? They had basically Union soldiers throughout the state running the states. The freedmen were allowed to vote. You actually had black members of Congress elected. Hiram Revels was the first African-American senator from Mississippi, of all places. My goodness. God, another guy, I'm blanking his name, another person from South Carolina. I mean, you actually had African American members of Congress in the 1870s. Okay? Now, I don't want to sugarcoat this. It was not a happy period. There was a lot of violence and lynchings. And think of the Crookshank case, right? Remember the Colfax Massacre. These were not, these were very hard times during the Reconstruction period. And by the time you get to the 1880s, the appetite for Reconstruction starts to fade. The southern states are exhausted. They don't want to live under it anymore. And the northern states said, we don't even care anymore, whatever, right? We tried this for 20 years. We need to move on with our lives. So slowly the Union Army started pulling out of the South. And as the Union Army started to pull out of the South, James asked about black codes after the Civil War. They had them, but not like in the 1890s. In the 1890s, it really got ramped up. After the Union Army pulled the South and Reconstruction began to end in the 1880s, the southern states began to experiment with more and more elaborate Jim Crow measures. So Louisiana didn't segregate its its modes of transportation until 1890. This was actually considered a very significant statute at the time. It was a test case, right? We keep using this phrase, test case. This was designed as a test case to see if a state could segregate its institutions, right? The civil rights cases was a private business, right? Private businesses were segregating. But here we had the state segregating. Okay. Colin, are you here?
Yes.
Okay, Colin. Thank you. Thank you for asking. I'm very well. Thank you. A little tired, but doing all right. Colin, you want to give me the facts of Homer Plessy and what happened with him?
So he was an African American who was, he tried sitting in the white section of the train and was subsequently arrested and imprisoned.
Okay. He was deliberately arrested, right? How do we know he was deliberately arrested, Colin? What is some of the evidence that we have?
It said that he was 7/8 Caucasian and 1/8 African American blood. And for that, he was singled out because he took possession of the vacant seat.
Okay. Okay. All right. Thank you. So we have this guy, Homer Plessy, who, by the way, there's no photographs of him. If you Google Homer Plessy, you'll find pictures of him, but it's not him. It's another black guy from the era. It's actually embarrassing. We had a presentation at the law school a year or two ago. I can't remember who gave it from another school. It came in, and he had a PowerPoint up, and he had a PowerPoint picture of Homer Plessy, and I'm like, yeah, that's not him. It was a little embarrassing, but yeah, that's not the guy. It's someone else. It was actually, oh God, was it the governor of Mississippi or Louisiana? It was some other Louisiana figure, and I don't know. Someone on the internet screwed this up at some point. It keeps getting repeated, so we don't have a photograph of him. In fact, I think there are 2 cemeteries that claim he's buried there. It's a very, mysterious person. We just have no record what the guy looked like. But apparently he was phenotypically white. But he deliberately went to the white car to get arrested. That was his goal. He wanted a test case. We know it's a test case. He got bailed out right away. And it was a high cash bail, right? This wasn't like, a $5 bail. This was an effort to, get the guy. He deliberately was arrested, and then he challenged the ordinance as being a violation of the 14th Amendment. Okay, so Homer Plessy is the guy in the train car. Who is Ferguson? This is a weird rub of Louisiana law, which I don't fully understand. I've asked about it. I still don't fully get it. But in Louisiana, if you're challenging a criminal sentence, you actually sue the judge who issued the sentence. So Judge Ferguson sentenced Homer Plessy to the crime. So who's Plessy and Ferguson? Ferguson was the judge. And in Louisiana, you sue the judge to try and get a writ for the judge to vacate your sentence. It's a very weird... Louisiana is a weird law. I'm sorry if anybody from Louisiana. It's just it's everything's very different there. It's a civil code. I don't understand it. I understand it, but it's very different. All right. And so this case goes up to the U.S. Supreme Court. Now keep in mind where we've been, right? You have you have the 14th Amendment was ratified, and then a couple years later you have Slaughterhouse. And Slaughterhouse says that the privileges or immunities clause are limited to these narrow sets of federal rights. And you have Cruikshank, which says the privileges or immunities clause does not protect the enumerated rights. And so the Colfax massacre was, not remedied. Then you fast forward to Strouder. Strouder held that the state cannot deny, exclude black men from the jury. Okay? That was Strouder. But then you have the civil rights cases, which held that Congress lacks the Section 5 powers to prohibit private discrimination. Okay. So Strouder says the state cannot exclude black men from the jury, but civil rights cases said that the states or state businesses can exclude black customers. All right, so you see, I want to get the chronology. Okay. Then we go to Yick Wo. And Yick Wo holds that this ordinance, which was arbitrarily denying Chinese people their licenses, was unconstitutional. It was acting on with an evil eye and an evil eye and an unequal hand. Okay. So again, Strouder and Yick Wo suggested that the states can't be engaged in racism. But the civil rights cases said private parties can. So we get to Plessy. You would think that the precedents that are most relevant in Plessy are Strouder, which was the jury service case, and Yick Wo, which was the laundry case, right? You would think the court would simply say, well, the government can't exclude black men from the jury. The government cannot arbitrarily deny Chinese people their licenses. Therefore, the government cannot forcibly exclude black people from the white card. You would think that is how the court comes out. If that's what you think he thought, wrong. Okay, who's next? Is that Brigitte?
Yes, sir.
Brigitte, okay, let's walk through Justice Matthews' majority opinion. By the way, just 1 second, Brigitte. Everyone knows Roger Taney, who wrote Dred Scott. But no one knows Henry Billings Brown. Who the hell is he? Well, he wrote the Plessy decision, 8-1. Everyone knows Dred Scott and Roger Taney, but for whatever reason, people know the name Plessy, but the name Henry Billings Brown just faded into history. There was a what do you call it? There was one of the justices in the court. I'm blanking on which one it was. Melville Fuller, right? When Plessy was decided, Melville Fuller was Chief Justice. You've never heard of him, I'm sure. Not very important. We actually did some Fuller cases. That's wrong. So you have heard of him. He was from Maine, the state of Maine. And the state of Maine doesn't have many famous judges. So there's actually a statue dedicated to Melville Fuller in Maine. And there's actually a movement now to remove the Melville Fuller statue. Why? He didn't write the majority in Plessy, but he joined the majority in Plessy. So even this sort of taking on statues things is I think finally catching up with the Plessy court. I don't know if there are any statues of Justice Brown. I have no idea actually, but at least the statue of Justice Fuller is probably coming down. All right, Brigitte, I'm sorry. Go ahead and give me the facts, please, in Plessy.
So there were two separate holdings. First pertains to the 13th Amendment. The second pertains to the 14th Amendment. First, Justice Brown indicated that the the segregation law did not violate the 13th Amendment.
Okay, let's start there, right? Why did the segregation law not violate the 13th Amendment?
The implication of a legal distinction between the races wasn't something that went to the destruction of the equality attempted to establish through the 13th Amendment.
So how did he define slavery? And I posed this question to you guys earlier, Bridget. How did Justice Brown define slavery?
Involuntary servitude.
That's it, narrow, right?
Yes.
Clear. Very good, thank you, Bridget.
Yes, sir.
Okay. So we have two possible amendments to one good thing of having a camera, you can see when there's food on your face. Whereas, so the first part of the analysis focuses on the 13th Amendment, right? And we asked about the badges of slavery. That's how we opened up our class earlier today. And the court says that the 13th Amendment only prohibits state of bondage, which describes ownership of man as chattel. And the court says that a statute that suggests a distinction between the races doesn't destroy legal equality. The court makes this huge difference between legal equality and societal inequality, right? They say Strouder was correct that you can't exclude black people from a jury service, right? Because that's a legal sort of equality. But they say that the train car is not about legal equality. And he says that there are differences between the races, and the law can't hide that. Now, I think Emily? Emily, you here? Now, Emily, why did Louisiana adopt this law? Why does Louisiana?
I would say most likely because just to discriminate so that they aren't together. They were probably a bad motive, I would say.
I think you're saying they were racist. Is that what you're getting at?
Yes.
Okay. All right. Well, so I think we can all agree that this law is motivated by racism. But if you were the lawyer for Louisiana, how would you defend this law in court? You can't go in there and say, yeah, we think black people are inferior. That's not the argument you're going to make. What's the argument that Louisiana made there?
I think they kind of compare it to how they separate the schools, the race, like the children's schools. Like they said that that's not a problem either. It's just keeping the commingling of the two races, they said.
Oh, wait a minute. What's the problem with mingling of the races? What's the problem there?
Well, they said that there wasn't a problem.
Who's they?
Louisiana, the government.
The government said...
That was their...
I'm sorry, let's be clear. Did the government want to mingle the races or did not want to mingle the races?
Did not.
Right. So why did Louisiana not want to mingle the races? What was their concern? What's the risk of what might happen if black and white people were allowed to sit in the same train car?
They would be like get along. I mean, they didn't want that. They didn't want.
What might happen if they're allowed to sit together? What happened in the Colfax massacre? Louisiana, say also Louisiana. What happened in Crookshank, Emily?
Oh,
Remember? Okay. Connor, you here? Connor, what would happen if the races were allowed to commingle, to use the phrase Emily raised?
Well, they said that they would fight and they wanted to be separated. And they did it for the good of the people and for the public peace and good order.
Public peace and good order. Just explain that for a minute. How is this order in the public peace to separate the races?
They were trying to prevent them from fighting, I guess.
So this was actually for the benefit of the black customers. So you're saying Homer Plessy should have been grateful for this law, for his own protection.
That's what Louisiana's saying, yeah.
Yeah, okay. Thank you for that, Connor. It's it's a kind of a remarkable argument, just if you take a step back and think about it, right? That this law was sold as a way to help black people. That if they were allowed to sit in the same car with the white folk, then there would have been all these lynch mobs, and this was actually for their safety. Laura says gaslighting. Yeah, okay. I don't know if that word existed in the Actually, no, I think it may have. I think the origin of gaslighting is a strange phrase. There was a book or a short story where there were these gas lamps, and you would let the gas out when you would inhale the gas, became hallucinating. That's, I think, where the origin is. It's the gaslighting, so you can Google me on that one. But yeah, the thinking there is this is actually for their own benefit, right? Because it's keeping them safe and preventing racial discord. And the court says some pretty remarkable things. The court says that this law does not stamp the black people with this badge of inferiority, right? And he says if black people think this law is marking them with inferiority, it's their fault. They're choosing to place that construction upon. In other words, this law is not making people separate. I'm sorry, damn it, I screwed up. This law is not making people unequal. It's just keeping them separate. They're equal, they're just separate, which is where this doctrine came from. And if you see this doctrine as making you unequal, that's on you, not on us. It's a stunning holding. I mean, you can imagine the court simply saying, this is a close call, we're going to defer to the state. But here they're endorsing Louisiana's theory of the case. They're endorsing it and saying that this is designed to keep people safe. This is a public safety measure. And if you see it's racist, well, that's on you. That's not on me. Don't come complaining to us, right? But then why did Louisiana enact this law? It wasn't for safety. There's an evil eye here that's fairly patent, which is why I have to give you, I forgot to ask a minute ago, was it a due process case or was Yick Wo equal protection? I really think if you want to look in this hindsight, you have to view Yick Wo as more of due process. It just doesn't fit with Plessy decided 10 years later. All right. Next, the court turns to the 14th Amendment. And the court says that this is a reasonable exercise of the police power. The police power is this authority of the state to protect the health, safety, welfare, and morals of the people. Health, safety, welfare, and morals of the people. And this law was not arbitrary. It was a reasonable exercise of the police power to promote the public peace and good order. Now, the court cites no evidence to say this is actually about promoting public peace. Right? There's no evidence where actually, all these fights breaking out on the railroad. By the way, the railroads didn't like this law for an economical reason. They had to pay for 2 cars instead of 1, right? Let's say there was only enough traffic to justify 1 rail car. Now that's have 2. So, I mean, completely aside from, race, whatever, they oppose on economic grounds. Yeah. Moses writes a problem with general welfare. If you take a very broad definition of what's in the general welfare, right, it can sweep in anything. So maybe, one person's definition of general welfare is racial equality, and the other one is to avoid the tension between the races, right? when you say you defer to the government's definition of general welfare, you're giving, you're endorsing a vision that maybe you agree with, maybe you don't. Now, let me just flip it for a minute. Which branch of government is better able to decide what's in the general welfare? The elected or the elected legislature or the appointed courts? It's also problematic when the courts assert their own conception of the general welfare that's inconsistent with what the legislature says. Right? There's no easy way around this issue. You get backed into a hole either way. But I think here the court goes out of its way to not only defer to Louisiana, but to embrace their reasoning. It reminds me of the Hirabayashi case. Remember the first Japanese detention case, where not only does the court defer to the FDR government that there's a threat from Japanese Americans, but they endorse saying that these people are dangerous, that we should feel safe with this measure in place. So I think the line is not just one of deference, but they actually endorse the reasoning. Right? Okay. One more note on the Justice Brown majority opinion. The court makes a few observations about the 14th Amendment. They make one that becomes very important. In the 1860s, when the 14th Amendment was ratified, Congress had full power over the District of Columbia. Excuse me. Congress at the time had segregated DC schools. Right? They segregated DC schools. And the court says, wait a minute. How can we possibly say that the framers of the 14th Amendment intended to eliminate segregation in public institutions if they themselves impose segregation on their own schools? Now, this is a very common argument, and we'll come back to when we study Brown v. Board of Education in about a week or two. Let me just put a bug in your ear, though. This argument's not airtight. And I think there's a pretty compelling, maybe not persuasive, but a compelling historical argument that it isn't quite right. That in the years following the 14th Amendment, there were strong movements in D.C. to eliminate segregation in the schools and to integrate them. And for reasons that are not, I don't have time to explain right now, it didn't work. But I don't think it's easy enough to say that everyone in the 1860s thought this way. There was a diversity of opinion on this issue. But it goes back to a debate we keep having. How do we read the Constitution? Do we look at the intentions, the silent intentions of the framers, or do we look at the text that they adopted? Frederick Douglass and Spooner and others said we can't look at what the intentions are. Their intentions don't matter, right? Let's look at the words they use. The Constitution says nothing about slavery. So under that school of thought, it doesn't even really matter what the framers thought. What matters is the words they use. And the words they use are pretty broad: equal protection of the laws. So the DC school thing, it often comes up. I don't think it's sort of the sort of blockbuster argument that shuts everything down, but it does come up very often. All right. Questions on the Plessy majority? Nothing? Really? Okay. All right. Let's move on and do the Justice Harlan dissent. This is probably one of the most famous dissents in the history of the Supreme Court. It's legendary. The civil rights dissent, I think, is actually. Stuart, go ahead.
I have to go to work, but class is over. How long are we going to go on the dissent for?
I'm sorry?
I have work right now, and class is over. How far are we going to get into the dissent right now?
I need 2 minutes.
Okay.
If you need to go, then go. I'm sorry, but I need like 2 more minutes. I'm sorry to keep you a little bit wait. The Justice Harlan dissent. It's too important to go over. I'm sorry. I can do a little bit late. I'm sorry. The Justice Harlan dissent is legendary. And I think one of the reasons why it's so significant is he was alone, and it's not easy to be alone, especially when you're speaking of an issue of such national consequence. And I think Harlan saw where things were headed. I think Harlan recognized what would happen if this rule became the rule of law, right? That if Plessy became the rule where we were headed, and I think he recognized that the Jim Crow movement would get like a shot of adrenaline because of this. So once again, Harlan talked about the 13th and the 14th Amendment. In his mind, this is an easy case under either one, that the arbitrary separation on the basis of race on the highways, on the roads, is a badge of servitude. That this is clearly in Harlan's mind designed to restore and reflect the state of slavery that existed before the 13th Amendment. He also wrote that the 14th Amendment is violated, that we have a colorblind constitution that neither knows nor tolerates classes. He says there's no dominant and no superior class. There's no inferior class. All citizens are equal before the law. I just want to flag this notion of the colorblind constitution. We'll come back to it when we do the affirmative action cases. Not everyone's so keen on this expression because for some of these decisions, racial preferences are preferred, which is not colorblind. It's actually the opposite. But race is used in what they call a positive racial preference fashion. All right. Harlan also sorts of says this law makes no sense, right? Why are they doing this, right? Is this actually about promoting the public safety and welfare? There's no evidence that there's ever even such a problem. They basically made up a problem and designed a statute to address a made-up problem. Finally, Justice Harlan says this case will go down like Dred Scott. The same way that Dred Scott has been viewed for generations, so will Plessy. And I think he was quite right. All right, I'll stop here. I'll turn on the minute poll. I'll be back here around 12:30 if you want to take some questions for office hours. I'm sorry to keep you late, but I think it's just a little too important to wrap up abruptly. All right, thank you all so much.